I should allow Ms Mitchell to examine Mr Brown on the following issues. Issue number 1, whether there were any processes, practices or procedures in place to monitor the obtempering of the Crown's duties under Articles 2 and 14. Issue number 3, the extent of consideration in the analysis of whether Mr Bio was suffering a mental health crisis. Issue number 5, whether when Mr Brown consulted with Deborah Coles of Inquest and the Lord Advocate, there was any discussion about racial links to excited delirium. And issue number 7, the issue of race in relation to the perception of threat and danger. In relation to the other issues, I consider that I would not be assisted by examination of this witness in relation to these. So can we have the witness back now, please? Ms Mitchell. Good morning, Mr Brown.
Good morning,
Ms Mitchell, Senior Counsel for the families of Sheku Bio, has some questions for you.
Thank you.
Ms Mitchell.
Thank you.
Good morning.
Good morning. We've heard quite a lot about Article 2 and Article 14 and the Crown Office responsibility in that regard.
Yes.
And you've explained that you were, broadly speaking, confident that everybody knew and everyone understood their duties in that regard. But it might seem to the outsider that perhaps Mr Anwar was having to remind the Crown of various duties under Article 2 and Article 14. And what I would like to know is, was there any processes or practices or procedures in place that could monitor whether or not the Crown was obtempering its duty, and whether or not there were any person who was giving feedback on that or overseeing that duty within Crown Office?
I don't think I could say that there was anybody overseeing that in that sense. I do recollect that there was repeated mention of the duties under ECHR. And in respect of law officers, I'm aware from correspondence that the Lord Advocate's view, and I hope I'm not misquoting him, was to the effect that compliance with ECHR could only properly be assessed at the end of the whole investigative process, and the investigative process was still ongoing even after Crown Counsel took their decision. What I can say also is that in respect of the overall approach, and in respect in particular of the obligation under Article 2, the right to life, and the obligation in respect of Article 14 as it affects all of the rights under ECHR, the right or the obligation to consider discrimination, that when one considers the approach that is recommended to be taken in respect of that, and by that I mean the guidance issued to IPCC, which I was directed to as part of my statement questions, that does set out how that should be approached, and in some respects it might be regarded as best practice. and in order to assess that, that guidance does say that at the centre of that there has to be consideration of the position of the officers of the police, and that the structure of that, in broad terms, and I think I'm quoting the guidance, that one should assess what the actions of the officers were. Then one should assess from the officers what assumptions they took into account. And thirdly, once you've got to stage 2 of that process, you should explore with the officers why they made those assumptions. Now, I would suggest that that requires an investigative approach, and an investigative approach that wasn't open to the Crown, having regard to the stage that the investigation had reached when the second PERT report came in, because Crown Counsel were clear that having regard to that stage, that the Crown could not approach the officers, and as far as I can recollect, Mr Anwar accepted that the Crown could not recognise the officers.
Well,
and
can I ask you, sorry, to come back more to the point that I was focusing on, which is, was there anyone in Crown Office when that work came to an end who would look back and review and see whether or not there had been compliance with Article 2 and Article 14? Like many public companies, there is a review process carried out to ensure that they're tempering their duties in regards to what the law places on them, be it health and safety or whatever. What I'm asking specifically was there somebody to carry out that process, and were there practices, procedures and protocols put in place for that purpose?
As I said at the start, there wasn't a person who had that overall oversight.
Were there any practices or procedures put in place if there wasn't a person? Was there anything that could be done to, at the end of an investigation, where you're assessing, did we do that right? Have we done our job? Was there any practice or procedure in place for that to be done?
Well, as I said, the investigation was not at an end, even when Crown Counsel took that decision. There was not a person who had overall oversight in respect of that, but my expectation would be that the kind of considerations that would require compliance with ECHR would have been a consideration as the investigation moved on once Crown Counsel had reached that decision.
And had that investigation moved on and had been completed, was there a practice or procedure or person to do that?
I'm not aware of such a person. Quite what action would have been taken if it had moved on to the inquiry phase, rather than moved on to the right to review and then the public inquiry phase, which is what obviously we're engaged in just now. It is speculation on my part, but I do say that to get back to the stage that the inquiry had reached, it was for the specific and limited purpose of assessing whether there was a basis to take criminal proceedings, and that was the end of that phase of the inquiry, but it was anticipated that it would move on to another phase.
I'd like to move on to my next question. We covered, my learned friend, with you in some detail on Friday, and indeed the preceding days covered the Crown analysis that Ms Carnan had brought together. By the time that the Crown analysis was brought together, had you read the civilian and the police statements?
I'm trying to think back to at what point I had read a number of statements up until that point. I don't know that I can say it what the statements were that I read.
Do you recall whether or not they were the police statements or the civilians or a mixture?
I suspect they were a mixture.
in those police statements, because we've obviously been through them, and in the civilian statements, there was a significant body of evidence, if it was chosen to be accepted, that Mr. Bio was suffering from a serious mental health episode. Police officers themselves, even before they got there, thought that might be a possibility. On arrival, his manner, his deportment suggested such. Officers said it. Even civilians, prior to the police arriving, reported in such a way that he may be suffering from a mental health episode. The Crown analysis does not appear to consider properly Mr. Bio's mental health in the context of how the officers dealt with him from the outset. Would you accept that?
What I would say in respect of the analysis and that kind of information is that when Crown Counsel were making their decision, clearly there was a recognition, there was that information, there was that analysis prepared by Fiona Carnan, but there was also the significant process in this case of Crown Counsel being able to consult with experts themselves, and in particular the expert on restraint who was identified for the, hopefully from the purposes of being able to comment on the overall approach of the officers from an independent point of view. And what I am confident of was that a key focus in respect of that was whether the officers should have recognised the signs that Mr. Bio may have been suffering from what I would generally term a mental health episode, and that was part of the overall assessment of the restraint expert, and it was part of the overall assessment of Crown Counsel as to whether those aspects were of relevance to the consideration of criminality.
Should it have been included in the Crown analysis?
It might, with hindsight, have been better, but what I can say is that I don't want to speak particularly for Crown Counsel, but Crown Counsel had a significant body of information, including information in respect of that from their own consultations.
Given that it wasn't in the Crown analysis, would that limit what further inquiries might be made had it been fully set out in the Crown analysis?
I think my assessment of that is that all of the relevant information in respect of the police officers' approach and their actions was before Crown Counsel for their consideration as to whether there was a basis for taking criminal proceedings.
But that might not have been included in the analysis?
I'm confident that Crown Counsel had that kind of consideration in their mind and had information to enable them to make a properly informed decision in that regard.
Is there a reason that it wouldn't be included in an analysis?
Overall, the purpose of the analysis is to assist Crown Counsel in coming to a decision on the specific and limited purpose of reaching a decision on criminality.
So is there a reason it wouldn't be included in the analysis, the way Mr. Bio was acting, what people had said about his mental health, for example, whether or not the police had ignored a direct order to pause and report back before they engaged with him?
Overall, in respect of all of the considerations of Crown Counsel, I am confident that the question of whether the officers should have recognised and whether their training in particular equipped them to recognise identifying somebody who might be suffering from a mental health episode.
Well, forgive me, but my specific question isn't about what Crown Counsel was considering or decided. My specific question was whether or not that should have been or would have been appropriate to have in the Crown analysis.
It would have been appropriate if it were relevant to the consideration of criminality, but as I say, it was something that was as far as I'm concerned, explored by Crown Counsel, who were, of course, the ultimate decision makers during the course of their own inquiries and their own consultations.
And following from that, do you accept that the question of Mr. Bayo's mental health, whether or not he was having an episode at that time, was relevant to the issue of the criminality of the police officers?
I'm not. No, I don't want it to be taken that that must have been relevant and was not properly assessed by Crown Counsel. I am confident that Crown Counsel did have sufficient
I'm
information.
not asking about
before
Crown
them.
Counsel,
So,
I'm asking about the content of the analysis and whether or not that should have been included.
I will obviously try to answer your question. The assessment of the actions of the police officers, and in particular whether their actions amounted to criminality or were wholly unreasonable in all the circumstances, that was something that was assessed by the expert witness who took into account whether they should have recognised that. So to that extent, it was something that was addressed and was in the minds of those who were making the decision.
I'll just ask one last time, should it have been in the analysis?
Well, with hindsight, it might have been better if it was in the analysis, but I suppose I'm not agreeing that its absence would have affected the decision that Crown Counsel had to make.
Thank you. Moving on to my next question. In your evidence, you said that you weren't aware of the connection between the term excited delirium and a link to racial cases. You said that earlier in your evidence. Do you recall that? It was 3 days of evidence. I appreciate
sorry.
that, but maybe I'll just go back. The bit of evidence was when you were discussing with my learned friend the issue of race and excited delirium, and it was put to you that the idea of excited delirium in and of itself had issues of race and racial connotations, and I think you accepted that you weren't aware of that. Is that correct?
That may well have been the case. The specific link, I knew that it was a condition that had attracted some controversy. Yes.
I see, and that controversy was related with race, or not?
I don't recollect knowing that it specifically was connected with race. I didn't have familiarity with it prior to my involvement in this case, and I suppose trying to look back, and it is difficult to separate what I knew when in respect of it. I certainly later on knew that it was something that was controversial, and that perhaps it had particular resonance internationally, and particularly in America. So I suppose to that extent, if one were looking at cause of death and deaths following restraint and in custody, it would be reasonable to assume it might have a racial element. But I don't remember knowing that at the start, although it might be that Mr. Anwar did make that as part of the criticisms that he made.
Well, I'm just wondering, and sometimes things jog your memory, sometimes they don't, but I'm just wondering if you recall when you met with Mr. Anwar and Deborah Coles of Inquest, the issue of excited delirium having a link with race was discussed then. Would that trigger any memory with you? Do you remember speaking, first of all, about excited delirium, or
with Deborah Coles?
Yes, or restraint in police custody?
I did reflect on my meeting with Lindsay Miller and Deborah Coles and Mr. Anwar at his offices. The recollection that I referred to in my statement was very much directed towards that the investigation had to be rigorous, and that criticisms had been made of the IPCC in respect of investigations, in particular Sean Rigg, and that they are, I can't recollect if this was the specific reference that she used, but it was along the lines of that one shouldn't, the investigation should not seek to blame the deceased person, in this case obviously Mr. Bayo, for for the incident. That is what I took from the meeting.
Nothing might turn on it. It is just the inquiry may come to hear that such a discussion was had, but you don't recollect that at the time.
Sorry, I don't recollect. That was my main takeaway, if I can use that cliche, in respect of that. And as I've said in my inquiry statement, I did use that to inform some of the analysis that I presented to the Lord Advocate following that meeting. I have said in my statement that I did find the meeting to be valuable, and that is still my position in respect of it. It does provide a valuable perspective, and it did.
Thank you. I'll move on to my final issue, which is about something that you said in evidence on Friday to my learned friend. And if I can just refresh your memory, obviously it was a many days giving evidence. That's at page 134 and 135. So page 134, line 16, you said, yeah, no, I don't need it up on the screen, thank you. I'll read it out to you, just providing you with the context. You said, I consider the way that it was approached in this case, it'll become clear what we're talking about in a second, which the team and Crown Counsel were content with, was looking at the actions of the officers and assessing whether their actions and behaviour fell out with the range of reasonable options that were open to officers, taking account of all the relevant circumstances, including, in particular, the apparent threat or danger that could be posed by someone who might have been still in possession of a knife. And you go on to see then at line 135.2, I recollect it was the restraint expert considered that he was unable to separate out some of the elements that would have a potential racial motivation, such as terrorist threat, but that the most important factor that was under consideration was the degree of threat posed by someone who could have been in possession of a knife. Now, what I would like to ask you about is whether or not in the Crown analysis the degree of threat and the mens rea of the police officers was properly analysed. This inquiry has repeatedly asked questions of people. Would you have dealt with someone in this way if they had not been white? Just to see whether or not the answer would be yes to that. We hear that attending a knife crime was unfortunately a very common thing for police officers to have to do. And indeed, on many occasions when they attended, we've heard stories of the person being armed with a knife. Of course, we know as a matter of fact, Mr. Bayo was not. So the question surrounding what was in the minds of the police officers when they arrived that day, they came to this knife incident, was obviously crucially important. What was their mens rea? And what I would like to ask you was whether or not you think their perception, the perception that we hear about from things that they have said, their perception of threat and their perception of danger may have been specifically related to the colour of Mr. Bayo's skin. Do you understand the question that I'm asking?
I think so.
Okay. Do you think that was properly analysed by the Crown?
I consider that kind of important consideration was a factor in relation to the focus of the Crown investigation and in relation to, in particular, whether the standard of criminality could be established. I do recollect, obviously, with you reading it out, that passage, that I was going back to what I recollect the assessment of the restraint expert being, and as I recollect it, there was a particular focus upon the initial approach of the officers, taking into account a number of factors, but that the main factor, according to the restraint expert, that had to be assessed and taken account of in relation to the initial approach to Mr. Bayo, which I think could be reasonably described as assertive, that was a course of action which was open to the officers, and therefore that assessment could inform, it would not be determinative of the issue of criminality, but it could inform and, I suppose, assist Crown Counsel in reaching an assessment as to whether the standard of criminality had been established.
Again, I'm really looking more at the moment at the analysis that the Crown did. So I'm not asking what the expert witness, what Mr. Greaves said or what Mr. Greaves discussed. What I was wondering was, did the Crown analyse the mens rea of the police officers in relation to race? Did they look at the statements and note that there were terms used that were of a racial nature, the word coloured, etc.? Did they note stereotyping that might be common in the idea of black man being more aggressive or superhuman strength, or all those sorts of phrases that we've covered in the earlier part of the hearing? Was an assessment done in that regard by the Crown?
I'm confident the team were aware of those kind of considerations as they related to specifically the mens rea of the crime that could potentially have been committed. I do come back to the point that I made at the start of this morning's session, that considerations of the approach of the officers could only, in my view, be properly assessed when one had the opportunity of asking why the officers took that approach. And it would require, I think, careful, skilled and experienced questioning within a framework in order to assess those kind of considerations.
And that inquiry hadn't been carried out?
That inquiry could only be carried out, in my view, when one had the opportunity to embark on the inquiry that was envisaged by the IPCC guidelines, where there was a three-stage process where one looked not only at the actions but looked at the assumptions that were made, and importantly why those assumptions were made, and all of those would require an approach to the officers.
When considering the issue of mens rea, did anyone, as far as you're aware in Crown Office, sit down and think, we have to consider the issue of race in relation to all matters of this inquiry? Is it possible that the way the police officers acted and the way that they produced a hard stop on arrival, that Mr. Bayo was sprayed quickly, that he was on the ground very quickly, could the way the officers have acted have been influenced by race, and analyse that race through what they said and what they did in the statements that you had?
I consider that to embark upon that process when one was precluded from approaching the officers did risk coming to an assessment that could be either described as partial or incomplete or potentially wrong.
Well, you
that
weren't
that was an
precluded.
essential
You
part.
weren't. Oh, sorry. You weren't precluded from looking at the language that was used
Yes.
by the police officers.
Yes.
You weren't precluded from looking at various tropes that were displayed within the course of that, and that might have provided you with a basis for doing that. Did anyone look at those things and say, I think we've got an issue here, I think race might be part of why they reacted in this way to this particular man?
I do consider that that would be relevant to an inquiry phase, but only once the assessment of criminality had been taken, and that the approach, the overall approach of the officers and their actions was assessed and was part of the assessment of the Crown team as it related to the issue of criminality.
But doesn't the issue of the mindset, the mens rea of the officers, are intrinsically linked with identifying whether or not there'd been a criminal offence?
I am not going to assess that, because I appreciate that this is a core issue for this inquiry, to assess whether there was discrimination, and that does involve, I would suggest, quite a different approach. But the approach that was taken by the Crown was at that stage to exclude criminality, and I'm satisfied that the Crown team were able to present to Crown Counsel an assessment of the relevant issues, and also that Crown Counsel being part of the team, because I do consider that it's an important consideration. This wasn't all going one way to a Crown Counsel who was opening up the recognition at page 1 and starting to read their way into it. By that stage, Crown Counsel had been embedded in the whole process, had directed some inquiries themselves, had conducted consultations with key witnesses, and that they considered they were in a position to make a decision on that, but that the inquiry was not concluded at that point.
If it wouldn't have been right to make a decision on the issue of what the police were thinking without statements, how were you able to assess whether or not the actions were criminal or not without those statements?
Because the overall information, the assessment of the broadcasts, what information had been given to the officers, that was all an important and a very rigorous part of the Crown assessment. Also, a specific inquiry as to the actions of the officers after the incident, and trying to ascertain whether any comment had been made, either on the way back to the police station or back at the police station. All of those were a key focus of the inquiry at that stage in assessing what information was available to the officers and what their reaction was. So that was the focus of the inquiry.
So if I can just interrupt you there, those are relevant issues as to what the thinking of the officers were, what they were saying at the time, what they said after it.
Yes.
What I'm saying was did somebody actually do that? Did anybody at Crown Office say, look, there's language that is being used here that is of a racial nature, and there are stereotypes or tropes we may see coming through those statements? Did anyone in particular flag that up?
The focus of the inquiry, of the assessment in respect of the possibility of criminality, was in relation to assessing whether there was evidence that the officers' actions was grossly disproportionate, and that involved considerations of trying to assess at what stage Mr. Bayo was under control, and whether after that gross and disproportionate violence was inflicted upon him when the officers either knew or should have known that he was getting into difficulties, and whether there was any evidence of a loss of control or a loss of temper of the officers. And those were all relevant considerations, I would suggest, in relation to the overall question of could a crime, namely in relation to the incident itself, a crime of assault or culpable homicide, be established to a criminal standard.
So are you suggesting that if, hypothetically, police officers dealt with someone in a way different and performed a hard stop when that wasn't necessary, for example, it would not, the issue of criminality wouldn't focus on the minds of the police officers when they did that, but rather whether or not the stop could be justified?
I consider that key question of whether the stop could be justified was a key consideration of the restraint expert, who did comment specifically on that in the light of all of the information that the officers had.
Yes, but he didn't comment
time.
on the language used by the officers or the fact that tropes were identified. That doesn't appear to have been dealt with by him. So it's that particular bit that I'm asking you about.
No, he made his assessment for the assistance of Crown Counsel on the basis of key considerations, including in particular the potential threat that the officers might have considered at the time of their attendance.
Did anyone pose the question in Crown Office, given what we know about the statements and given what we know about the evidence of what the police did when they approached and they met Mr. Bayo, given those factors, do we think that this would have happened if the police officers had encountered a white man or a white woman?
I do consider that those questions were for the subsequent phase of the inquiry, but I do consider that relevant information that related to criminality was accurately assessed as part of that decision-making process.
So even
Ms Mitchell, I think
I'm obliged.
I really have the point now. I think we could perhaps stop now.
I'm obliged.
Thank you. Well, Mr. Brown, thank you very much for coming to give evidence to the inquiry. You've given a lot of time to the inquiry, and I'm very grateful for that. I'm going to adjourn to allow arrangements to be made for the next witness, and then you'll be free to go.
Thank you.
So we'll adjourn now. Good morning, Mr. Logue. Will you take the oath?
Yes.
You raise your hand and say the words of the oath. I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Graham.
Thank you. Good morning, Mr. Logue.
Good morning.
You are John Logue.
Yes.
What age are you?
I am 52.
You are now the Crown Agent and Chief Executive of Crown Office.
That's correct.
And as I understand it, that is the most senior member of staff in Crown Office.
Yes, that's the position. That's the senior permanent prosecutor, civil servant within the organisation.
Thank you. And you were appointed to that role initially on an interim basis in September 2022, and then on a permanent basis since December last year.
That's correct.
And you've been in Crown Office itself since 1994.
That's correct.
You've also held the roles of Area Procurator Fiscal in Tayside between 2010 and 2011.
Correct.
And between 2011 and 2014, you were the Procurator Fiscal for the East of Scotland.
Yes.
And I understand from your statement that essentially during that role you were investigating complaints in relation to criminal allegations against the police in those areas. And that was even before Police Scotland itself was established.
Yes, in those roles I had responsibility as the Senior Procurator Fiscal for a geographic area for a number of responsibilities, one of which was consideration of any complaints of criminal conduct by police officers.
And that would have included the area of Fife Police before they became part of Police Scotland on the 1st of April 2013.
That's correct.
In April 2014, you specifically became the Director of Serious Casework.
Yes.
And as I understand your statement, you said you were responsible for the strategic oversight of all High Court prosecutions, the investigation of serious and complex criminal cases, and the investigation of sudden and unexpected deaths.
That's correct.
And you remained in that role as at May 2015.
Yes.
And our main interest obviously is in relation to the events in 2015 in May. And I wonder if you could, just before we move on to the particulars, could you tell us a little bit more about your job in around 2015?
So it's a post which at that time, as you've described, was called the Director of Serious Casework. The Crown Office and Procurator Fiscal Service had restructured in a number of ways over a period of about 10 years, and it was a post which traditionally would have been known as the Deputy Crown Agent role in Crown Office before it was called the Director of Serious Casework. At that stage, when it was known as the Deputy Crown Agent role, the work of the Procurator Fiscal Service was distributed across the country in a number of offices, and every office carried out the same type of work, and therefore if an incident occurred in Aberdeen, it was the responsibility of the Procurator Fiscal in Aberdeen. If it occurred in Dumfries, it was the responsibility of the local Procurator Fiscal. So the organisation was structured at the point when I joined up until about early the late 2000s, early into the next decade, on the basis that the Crown Office operated as the headquarters, but a lot of the detailed investigative work was done in the local Procurator Fiscal's office. By the time I held the post of Director of Serious Casework, that had begun to change, and we were moving to a model where complex work in particular was carried out by dedicated units who could operate across the country, and therefore the role within Crown Office had begun to change, and so I still retained responsibility in May of 2015 for all High Court prosecutions, the preparation of those cases, all complex casework, and the investigation of sudden deaths, and also any significant mass fatality incidents which might occur. Then that would fall to me in the first instance.
And were those specialist units based in Crown Office, although dealing with work from all over Scotland?
Some were based in Crown Office, but some were based elsewhere in the country, depending on where it was most convenient to have them, and there could be a number of reasons for that, but they weren't all necessarily within the building of Crown Office at 25 Chambers Street.
Thank you. Have you had the opportunity to watch any of the evidence in the inquiry?
No.
No. Well, let me tell you, there is a blue folder sitting in front of you, and that should contain a hard copy of the Rule 8 request and the response from you, which is effectively your statement to the inquiry. Do you see that?
Yes, I have that.
That is for your use. Some people prefer a hard copy version, and if you're one of those people, then please feel free to use that. Now, when I ask you to look at a document, for the benefit of everyone who's in the room, we'll have things put on the screen in front of you, but it will only show maybe a paragraph or a couple of paragraphs. So if there's anything around that area that you think should be drawn to my attention, or you need as part of your answer, please just let me know, and we'll have that put on the screen as well.
Thank you.
And I should say that there may be other documents that you think would be of assistance, and if so, if we don't have them available on the screen, please let us know what they are, and we'll try and get them either over the next break or overnight.
Thank you.
Could we look first of all at the request for a Rule 8 statement, and this is SBPI 00441. Now, you'll see that this is, and if we can move down, we'll see a series of questions. There we are, role and experience. A series of questions which were sent to you by the inquiry team with a request that you answer those in writing and send them back to the inquiry.
That's correct.
And this is the process that was followed for your statement. So it wasn't a face-to-face or anything like that.
That's correct.
And can we look at your response to this, which is SBPI 00454? You'll see your name is at the top. It's from Crown Office. And if we look at the final page, you'll see that it's dated the 16th of January 2024. See, that's
26th, sorry. That's my handwriting.
Oh, sorry. No, it's my mistake. 26th of January 2024. And it's a number of pages, and you'll see that although our version is redacted, it's blacked out, I think on the copy you have, you'll be able to see that your signature was applied there.
The paper copy I have is also redacted,
Oh, right.
but I'm happy. That's
You remember
it's my
that you
handwriting,
signed
and I
it.
remember preparing the
Right,
statement.
thank you. And if we look at the final paragraph, we see, I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website. And you understood that to be the case when you signed.
I did.
And is it fair to say that you did your best when you were answering these questions to give a true and accurate record of your involvement in this matter that we're investigating today?
I did.
Thank you. Let's look at paragraph 4 first of all, and that'll be towards the top. Now, I think here in this paragraph you explain the role of Crown Office essentially. You mention the Lord Advocate. And I wonder if we can look at the final sentence. It says, in carrying out its functions, do you have that?
Yes.
Crown Office must ensure that the investigation meets the requirements of Article 2 of the European Convention on Human Rights and meets the needs of the nearest relatives. And so we've heard a number of witnesses talking about Article 2, and we've heard that there are 5 procedural obligations which should be observed to make an investigation Article 2 compliant. And they are independence, effectiveness or adequacy, it should be reasonably prompt, so there shouldn't be delay, sufficient public scrutiny should be available, and also the next of kin or the victim should be involved. And is that your understanding of the obligations in terms of Article 2?
Yes.
And then we've also heard about Article 14. Could we perhaps look at paragraph 59 of your statement? I think you mentioned this there. There we are. My view was at that time that the senior officials leading the investigation were all familiar with the Crown's obligations in terms of Articles 2 and 14 of the Convention. And again, we've heard a number of witnesses speaking about Article 14, and it'll be a matter for submission ultimately, but a number of witnesses have agreed that Article 14 requires that all of the rights in the Human Rights Act have to be protected and applied without discrimination. Is that your understanding?
It is.
Okay. And then we've also spoken to witnesses about a case called Nachova, where it was held that the authorities' duty to investigate the existence of a possible link between racist attitudes and an act of violence is an aspect of their procedural obligations under Article 2, but may also be seen as implicit in their responsibilities under Article 14, taken in conjunction with Article 2 to secure the enjoyment of the right to life without discrimination. Do you disagree with anything that's I've just said?
I don't. No.
And we've also asked witnesses who have agreed that in terms of Article 14, where there is a suspicion that racial attitudes induced a violent act, it is particularly important that the official investigation is pursued with vigour. And when investigating violent incidents at the hands of the state authority agents, state authorities have the additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events. Anything there that you would disagree with?
No.
And then finally, we've also asked witnesses to consider the phrase failing to do so, to carry out those reasonable steps and investigate with vigour, would be to turn a blind eye to the specific nature of acts that are particularly destructive of fundamental rights. Would you agree with that?
Yes.
Thank you. So if we look at paragraph 60, again you mention, I cannot recall any specific discussion about the application of Article 2 in my involvement in the investigation, but I was confident that the senior officials leading the investigation were all familiar with the Crown's obligations in terms of Article 2 of the Convention. And would that also include Article 14 of the Convention?
Yes.
And who are these senior officials to whom you're referring?
So those were the individuals who were more directly involved in the investigation than I was in May of 2015.
And who would they be?
So, for example, I had two direct reports, members of colleagues who reported directly to me. One was Stephen McGowan and one was Lindsay Miller. And I also worked very closely with Les Brown, who, if I remember correctly, was the head of our complaints against the police division. So we had centralised that work, as I spoke about earlier, into a dedicated team. And also David Green, who was the head, if I remember correctly at the time, of our Scottish Fatalities Investigation Unit. So we had, as I described earlier in relation to deaths investigations, brought that work together into a dedicated team instead of the traditional model of local procurators fiscal investigating deaths within their jurisdiction.
So we've heard that Les Brown was the head of CAPD.
Yes.
And we've heard from David Green also, and he was head of SFIU.
Yes.
We've heard that SFIU was actually a more senior position than head of CAPD. Is that correct? In 2015?
I can't, that could be correct. I can't remember the precise grading of the roles at the time.
All right. And then above that level, Stephen McGowan and Lindsay Miller.
Yes.
And they both reported to you.
Yes.
Thank you. Could I ask you some questions in relation to training? Could we look at, I think, page 23, which is paragraphs 107 to 110. But I'm interested primarily in page 23. Some of your answers span more than one page, so where I have it, I'll give the page number as well. Here we are. So this is 107, and it moves on to 110. And this is areas where you've been asked about your training in relation to training within Crown Office within your career. And if we could look at 107, you've talked about operational training in death investigations, FAIs, you include ECHR, homicide investigations. That was in the early stages of your career, you've mentioned, and they gave theoretical training. 108, you talk about attending diversity awareness training, senior diversity training, valuing and managing difference e-learning. And you also talk about completing online training through the civil service in relation to unconscious bias, equality, diversity and inclusion. And that's also featured in almost every leadership and management training course you've attended since you became a manager in 1999. And then at 109, you said Crown Office had and continues to have a range of guidance materials on equality, diversity and inclusion available on its staff intranet. We've heard evidence that there's a knowledge bank which is available to staff in Crown Office, which contains documents that can give guidance or advice to members of staff in the roles that they're performing in Crown Office. Is that correct?
That's correct.
And when you talk about a range of guidance materials being available, is it available on that knowledge bank? Is that what you were referring to?
It was, yes.
And we've heard that at one time that might have been hard copies, but nowadays it's all on the intranet.
Yes, yes. For quite some time, we moved away from distributing
Yeah.
hard copy for a number of reasons many years ago.
All right, thank you. I'd like to ask you about your, I'd like to ask you about these training courses, if I may. Can we begin with the diversity awareness training in 2004 that you mentioned in paragraph 108? Tell us a little bit about that course, please.
My recollection is that was a training course which was established by the organisation and was mandatory for all staff. If I'm remembering correctly, it was part of the service's response to the failings in the Chokar prosecutions and the 2 reviews which had followed that. And it was important that every member of staff in the organisation understood the findings of those reviews, understood what needed to change in the organisation, and also that staff were given what I might describe as the fundamental training on issues of equality and diversity in terms of dealing with the public and performing our duties, as well as aspects of how that also would impact on equality within the workplace. So it was a broad range of issues, but it came out of, I think I'm right in saying, given the timing, it came out of those reviews.
Thank you. How long was that course? Do you remember now?
I don't. There may be records to confirm it. My recollection is it was either a day or more than one day, or there may have been more than one element to it.
Right. And did it contain content regarding Article 2 and Article 14, as far as you remember?
I really don't remember, I'm sorry.
Right. And do you remember if there were any aspects of that course that were of particular assistance when it came to dealing with the Sheku investigation?
I don't remember during my involvement in the Sheku investigation specifically recalling or relying on any particular aspect of that training. I think by 2015, I think my understanding of the issues was informed by what I might describe as that fundamental level of training in 2004, and then experience built up since then in other matters.
Thank you. You then mentioned senior diversity training in 2010, and again, can you tell us a little bit about that course?
My recollection of that is not very detailed, I'm afraid. Simply that this was a more developed course directed towards senior members of staff in the organisation by that stage, which sought to update on issues, learning, and it was not like the training in 2004 directed at all staff. But I'm afraid I don't remember the detail of the content of that training.
Did it include training on Article 2, Article 14, or do you not remember?
I simply don't remember.
Okay. Were there any particular lessons that you learned during that training which assisted you in relation to the Sheco Bio investigation?
I can't say whether it was that training or whether it was litigation around that time, but a large part of our learning, which I think I drew on in relation to the Sheco Bio investigation, in particular Article 2, came from litigation which had drawn out in more detail and more understanding the consequences of Article 2, particularly for deaths investigations. And so by 2015, I think that was the main point that I was focused on in terms of the Sheco Bio investigation, in particular how that should lead the service to engage with Mr. Bayou's family at what must have been an incredibly difficult time for them.
Thank you. You then mention in 2014 you went on a Valuing and Managing Difference e-learning course. Was that an online course?
Yes, it was.
So this was a year prior to Mr. Bio's death. And I wonder if you can help us understand a little about this course.
Yes, my recollection of that is that it was more focused on workplace aspects of equality and inclusion.
Right. So did it include learning in relation to Article 2 or Article 14 in regarding investigations?
I don't think so. I don't think it was directed to our operational work. I think it was about workplace implications.
So was that course of any assistance in relation to the investigation into Mr. Bio's death?
Only in the general sense that it was a continuation of, it was an opportunity to continue and build up a general understanding of issues in relation to equality and diversity and inclusion.
Can we look at paragraph 109? You've talked about having a range of materials on equality, diversity and inclusion available. You say, I consult these materials as when issues arise on which I require guidance or when the guidance is changed. I do not remember consulting the material during the first few days in which I was involved with the investigation. That's into Mr. Bio's death. Did you have any cause to refer to any guidance that was available or seek it out in any way?
During that specific
During
time?
that time?
I don't think so, no. I don't recall, but I don't think I needed to.
Did you have any cause to seek it out at a later stage?
Not in relation to this investigation, no.
And then at paragraph 10, you say, I cannot identify any training which would have assisted in my involvement in the investigation. Do you think further training would have been of assistance to you when you became involved in relation to Mr. Bio's investigation?
In terms of my own direct involvement, I can't think of anything in retrospect, if I reflect on it, that where I felt there was a personal training need. That's not to say that there isn't value in continuous training in this area, but I can't say that links specifically to anything to do with my own involvement in the investigation.
In your role as director of series casework, was there any training need that you either identified at the time or subsequently that you would like to share with us?
I think in general terms, one of the priorities in that role was to ensure that I was aware of, for example, developments in any judicial consideration of our work, whether that be in the civil courts or in the criminal courts. And so there is, particularly at a senior level in the organisation, there's a particular responsibility on you as an individual to maintain your own professional understanding and legal skills and maintain an awareness as particularly as case law develops or legislation is introduced which changes matters. That was the other significant area where I would require to spend time keeping myself up to date.
You've explained to us how the head of CAPD and the head of SFIU were actually below Lindsay Miller and Stephen McGowan. In terms of who both reported to you, in terms of identifying training needs within their departments or their units that they were head of, how would that be shared with you, or would it be shared with you?
So that I would expect in my role at the time to have known if there were any significant gaps in training needs within either of these units. So for example, if I can't remember when the units were established, but I would have expected the people responsible for setting up those units to identify the skills and experience of the people joining the units, the requirements of the role that they were moving into, and then at an individual level identify what training needs. I would have expected to be advised of the training needs of each of the individuals in the team. But if that had identified, for example, that there was a significant gap across the entire team that could not be met from within the organisation, then I would have expected at that stage to know about it, because that would have been part of my responsibility to try and make sure that we were taking the steps to plug those gaps.
Would you only have expected to be made aware of that if there was a need to go externally for that sort of training? Or would you have expected to had that brought to your attention if there was training required, full stop?
I would have expected to know about it if there was a need for the training, full stop. Just to be absolutely clear, I'm not talking about the needs of individuals. I'm talking about a more substantive, wider issue within any of these teams. Then I would have expected to know about that, not necessarily because we had to go externally, but because I would have wanted to know that that had been identified and was being addressed.
So in the period up to May 2015, had any issues been brought to your attention where a training need had been identified regarding equality, diversity, inclusion, or Article 2 or Article 14?
I don't remember being advised of any issue like that.
All right, thank you. Can I ask you now about resources?
Yes.
I think you touch on this in paragraph 113 in your inquiry statement. And you say here, the investigation was lengthy. I cannot say if it was unduly lengthy because I was not directly involved after the 7th of May. I'm aware generally that it was complex and there was significant engagement with the family's solicitor throughout. The investigation also started at a time when there was an unprecedented number of very complex investigations underway, and at a time when resource was much less than it is now, approximately 1,500 staff compared to 2,400 in 2023. Beyond those general observations, I cannot make any particular comment about the length of time taken or whether anything could have been done differently, other than to observe that lengthy investigations are incredibly hard for families to bear and cause great damage to wider confidence in the system. I'm interested in the issue of resourcing. We have heard that in around July of the same year after Mr. Bayo had died, there was also a crash, M9 fatal crash involving Mr. Yulin Bell. We've heard from PERC witnesses and we've heard from other witnesses that put considerable pressure on their resources because that was obviously a very high profile investigation round about the same time. You've talked here about there being an unprecedented number of very complex investigations underway, and I'm interested in your views on resourcing at the time, round about, first of all, May 2015.
So perhaps if I can explain, before I talk about the unprecedented number of complex investigations, I could perhaps explain a little background about the resourcing
Please
position.
do.
So the service by 2015, I think, on reflection, was coming to the end of a period of about 5 years where, based on my recollection, the resource available to the organisation had been essentially flat over a number of years, and that was because public sector financing after the crash in approximately 2009 or 10 did not increase in the way that it had been increasing before that. And so there was a need for the organisation to essentially operate within what's described as a flat budget. So the budget was not increasing, but costs would continue to increase. So the consequence of that over a period of time is that the resource available to the organisation, the staff available to do the work, decreases. That was not something that I recall was particular to the Procurator Fiscal Service. It was something which applied across the public sector at that time, and therefore it was a constraint on a number of different public services. What proved particularly difficult for the Procurator Fiscal Service at that time was the number of very complex investigations which happened to coincide with that period of time. So I could be wrong with some of these dates, but my recollection is that the Clutha helicopter crash happened, I think perhaps in November 2013. The incident in George Square involving the bin lorry happened in December 2014, I think, which would be just 6 months before Mr. Bayou's death. You've referenced the M9 incident. There were, I can't remember the specifics, but I think there were at the time 2 ongoing fatal helicopter crash investigations involving the helicopter industry in the North Sea, I think. So there were a number of ongoing investigations arising out of unusual incidents which cannot be, clearly the service has to respond to and cannot be predicted or factored into budget planning. And for those to coincide at a time when the resource available to the organisation was not increasing year on year proved a very significant challenge. The response of the organisation to that, which was led by the Lord Advocate at the time, was to seek additional funding where available from the government for specific large complex pieces of work. And I've described up until now some of the death investigations which we were carrying out. There were also a number of complex criminal investigations which were being carried out at the same time. And so the organisation led by the Lord Advocate did seek additional funding, and my memory is additional funding was granted, but that was for specific pieces of work, and therefore it would be expected to be time limited. And it's always very challenging in those circumstances to accurately identify at the beginning of a large complex piece of work what level of resource you're going to need. It's much preferable for the organisation as a whole to be properly resourced to be able to deal with the full range of the work that it faces at any one time. From 2016 onwards, that began to change, and that is the period of time that leads to the difference that I've referred to in paragraph 113, where the organisation grew from having approximately 1,500 staff to now being somewhere between 2,300 and 2,400 staff. And that was a recognition of there was a need for us to meet public expectations, particularly around the speed of investigations, and also to be able to engage with victims and bereaved families in the way that we would have liked to have done, but that with a lack of adequate resource, that becomes a very challenging part of the job.
And so those that increased resourcing began in 2016, you've said?
Yes, I can't remember the precise year, but approximately in the period we're talking about, the annual resource budget for the Procurator Fiscal Service was £108 million. That began to increase, and its current resource budget this year is approximately 220 million. Now, a significant part of that has to take account of the consequences of the COVID pandemic. Specific funding has been made available to the service to deal with, broadly speaking, the consequences for the court backlog, the criminal court backlog arising from the court shutdowns, and also the death investigation work which has followed from the COVID pandemic. So there is funding built into that figure that I'm describing to you of the current budget, which will come to an end when our work related to the COVID pandemic comes to an end. But even bearing that in mind, that puts the organisation now in a very different position from the one it was in 2015.
Thank you. Can I ask you about, in terms of your role as Director of Serious Casework, and what diversity was there in terms of the staff that were under you? So we've heard about Stephen McGowan, Lindsay Miller, and then we've heard about the 2 units, SFIU and CAPD. Can you help us understand what the position was in relation to diversity of staff?
I can't recall specifically in the 2 units that you've described. My recollection is that at that point, the areas of responsibility that I had totaled perhaps, I think approximately 600 to 700 staff, but I would need to check. And I can't give you any personal recollection from that time of those units, those 2 units, or that broader area of responsibility. What I can say is that I'm aware generally that this was a period of time where, and for some time before 2015, the organisation, in response to the reviews that I spoke about earlier, had put a lot of effort into attracting and recruiting staff for all jobs from a diverse range of communities across Scotland, and had succeeded in doing that, and had, I think, comparatively good data available to the organisation about diversity across the workforce as a whole. By 2015, though, that was really reflected in the entry grades to the organisation, and the challenge for the organisation, which remains a challenge, is to do all that we can to ensure that that diversity feeds through into the leadership roles in the organisation.
Right, thank you. Can we look at paragraph 5, please? I'd like to move on to your own experience. And you say here, I've carried out death investigations and supervised deaths investigations since qualifying as a Procurator Fiscal Deputy in '96. I cannot quantify the number of death investigations I was involved in over a 19-year period, and cannot recall whether any of the investigations involved deaths in police custody during or following police contact, or whether race was a factor. Given your experience, is it fair to say you've been involved in a large number of deaths investigations over your career in Crown Office?
Yes, I think I've either directly been involved in or supervised a large number of investigations. I've also, in roles where I've not been directly operational, so for example, for a period of time, about 4 to 5 years, I was the head of policy in the Crown Office. So although I was not directly operationally responsible for any investigations, I would have been closely aware of investigative issues that were being dealt with, progress of investigations, other developments that affected the work of the service. So I think my experience of death investigations goes beyond the operational ones to broader considerations as to, for example, that was the period of time when the organisation considered whether it was right to leave death investigations to be the responsibility of individual procurators fiscal, or whether there was a better way of doing it. And my memory of it is that Lindsay Miller led a particular piece of work, perhaps about 2010, 2011, and it was her recommendation that the organisation should move away from that model and establish a dedicated team which would build up expertise in deaths investigations.
Thank you. You don't recall whether any of them involved deaths in police custody or during or following police contact? Can you reflect on that now? Do you remember if any of them involved deaths in police custody?
I genuinely can't recall, I'm afraid.
If you had been involved in a death in police custody, would you have probably recalled? Or does it not have any indication one way or the other?
I can't say one way or the other.
And you also say you don't recall whether any of the investigations involving deaths in police custody or contact, or whether race was a factor. Do you remember any deaths investigations at all where race was a factor?
I don't, and in fact, in reflecting on that, coming here today, I think this is the only death investigation I can recall involving the death of a black man in circumstances like this. I cannot recall any other death investigation which the organisation has dealt with.
And you've been in Crown Office, presumably you started your traineeship in 94.
That's correct.
Qualified in 96.
Yes.
And you're now Crown Agent.
Yes.
Right, thank you. Were there other people working beneath you who had experience in deaths in custody where race was a factor, as far as you remember now?
I would certainly have expected within the death investigation team that in the 2 to 3 years that I think it had been established by that stage, that there would absolutely have been experience within that team of dealing with deaths in custody. I can't say whether any of those would have involved race as a factor or not.
Would that have been Cap D, or would that have been SFIU?
Sorry, I was thinking of SFIU there.
SFIU.
Yes. So, for example, if a prisoner had died in prison.
And we've heard that, at least to some extent, you expected that experience, that knowledge to be centred around SFIU.
Yes.
Now, I am going to move on now to your involvement, which I understand was concentrated between the 3rd and 7th of May 2015. But I'm also conscious of the time, and I wonder if you could give me a moment to address the chair. Would that be an appropriate time?
Take a break for 20 minutes. Ms Graham.
Thank you. I wondered if we could go back to your statement SPPI 00454 and look at paragraph 3 first of all. You say, and this relates to your involvement with the investigation. You say, my recollection is I was made aware of the death of Mr. Bile by phone on Sunday the 3rd of May. So that was the day that he died. I cannot remember who advised me of the death. In my role, I expected to be advised of significant new investigations out of hours. I was involved in oversight of the investigation between the 3rd and 7th of May 2015. I was then on leave abroad from Friday the 8th of May to Friday the 22nd of May and played no part in the investigation during that time. On my return from leave, my recollection is that I was made aware of developments in the investigation as one of a number of high-profile and sensitive investigations then underway, but was not involved in the investigation. Is it fair for me to say that from that paragraph, really your primary involvement in the investigation regarding Mr. Bile's death was between the 3rd and the 7th of May 2015?
That's correct.
And beyond that, although matters may have been brought to your attention, you didn't really have any direct involvement in the investigation.
That's correct.
Now, you've also told us that one of the members of staff beneath you is Stephen McGowan, and we've heard his name mentioned. And you say at paragraph 16 that in his absence on the 4th of May, so if we look at paragraph 16, my duty was to ensure that there was appropriate strategic coordination and support in Crown Office for the investigation. I would not usually be involved in the detail of an investigation such as this. My recollection is that in the absence of Stephen McGowan on the 4th of May on leave, I had direct contact with PERC, Irene Scullion. I do not recall having direct contact with PERC after that date. Race was not a factor in my becoming involved directly with PERC on the 4th of May. So just to recap, we've heard that the events took place on the 3rd of May. The Monday was a bank holiday, so that was a bank holiday weekend. We understand, we've not heard yet from Mr. McGowan, but you're also saying he was off on the Monday, the 4th of May. He may be, when he comes to give evidence, he may say he was back on the 5th. I'm wondering if you can help the Chair understand your involvement between the 3rd and 7th of May. Obviously, initially, Mr. McGowan wasn't present, but then he did become back. He came back from about the 5th. I just wonder if you can help us understand your involvement and how that changed when Mr. McGowan came back.
So I had forgotten that Monday the 4th was a public holiday. My recollection is that Mr. McGowan was involved on the Sunday, the 3rd of May.
Right.
I believe Mr. McGowan sent emails confirming the position during the course of that day. I can't remember who it was who called me on Sunday the 3rd of May, so it may well have been Mr. McGowan that called me on the 3rd. But my reference there to him not being available on the 4th is I have, as best as my recollection allows, a recollection that he and I had discussed perhaps on the Sunday that he wouldn't be available on the Monday, and I would therefore, in a sense, step in and perhaps perform some of the functions that he may well have ordinarily performed had he been available. The fact it was a public holiday for an incident like this would have made no difference to us. We would have carried out the work that was required, as we were doing on the Sunday and on the Monday. And his role on the Monday would have been to have a more direct involvement than mine, to provide me with updates, and to he would have been assisting with conversations with PERC, for example, on the course of the Monday. If the Monday was the public holiday, then we would have all been back in the office on the Tuesday, and that would have been the first day that we would have had any meetings together, including with the Lord Advocate.
Right. So your recollection, Mr. McGowan was involved on the Sunday. He may have contacted you to tell you about events, but wasn't available on the Monday.
Yes.
So you were stepping into his shoes that day. In terms of your involvement from the 5th of May then, because you've said that you were involved between the 5th and 7th of May, when Mr McGowan was obviously back at work during those days. Can you explain the nature of your relationship during those days?
With Mr McGowan?
Yes, what
Specifically.
in terms of your professional, the work that you were doing?
So when an incident like this occurs, there are a relatively small number of senior people within the organisation who become involved. And so over those days, Mr McGowan and I would have been in regular contact every day. His office in Crown Office was beside my office. We, for an incident like this, would have been talking throughout the day. If we'd been in separate locations, we would have been keeping each other updated with emails or phone calls. I don't specifically remember when the first meeting with the Lord Advocate would have been, but that would have been a very important meeting very early on that week. The Lord Advocate would have required to know the latest position, and my memory was that he was at work and available that week, and therefore, although I don't remember when it happened or specifically anything about the meeting, I do remember in a general sense that over the course of those days there were a number of discussions between Mr McGowan and myself, both of us and the Lord Advocate, and our role was to build up a picture of what this investigation would involve, what it would require, and to make sure that critical issues that were arising at that stage were being dealt with. The actual work to do those things would then be done by others.
Right, thank you. You've talked about having direct contact with PERC on the 4th of May when Mr McGowan wasn't present. Can you tell us about that contact you had with Irene Scullion?
I have a very general recollection that I spoke to Irene Scullion on that day. She wasn't someone I had a lot of regular contact with, and I'm basing this not just on my recollection, but also I think some of the documents I've seen, I think I've referred to having spoken to her. But my understanding was that, my recollection is that she was providing me with an update on what PERC had been able to establish by that stage on the Monday. And if I remember correctly, the post-mortem was taking place that day, and so the conversation may well have included an update in relation to the post-mortem. But what I was really trying to do was get, from my point of view, a clear understanding of what PERC had established and where the investigation was likely to go, and to identify if there were any issues that needed to be resolved. And then I would have shared that with other people, such as the Lord Advocate or Mr McGowan.
Thank you. Focusing on the 5th of May, so Mr McGowan's present. We've heard that he had a meeting with Les Brown, head of CAPD, round about the 5th or perhaps the 6th of May. And at that meeting, as I understand it, Les Brown he travelled through to Edinburgh to have the meeting in Crown Office, and he was advised that he would be taking oversight of the investigation into Mr Bio's death. I'm interested to what extent you had involvement in the decision to appoint Les Brown as head of CAPD to look at the investigation, have oversight of the investigation, as opposed to SFIU. We've heard evidence from David Green that he was involved on the Sunday, and he was the one who actually appointed PERC to investigate on the Sunday, the 3rd of May. Were you party to that discussion or the decision to appoint head CAPD to cover the matter?
I don't remember the specific discussion you're referring to, but I would have expected to have known and been involved in discussions at the very least around that meeting, if not actually to be part of that meeting. So it's possible I was there, and I don't remember any consideration as to Mr Brown taking the lead on that, but that, in my experience, would have been it would have not been an unusual response to an incident of this nature where Mr. Bayou had died after being in contact with police officers.
You've talked about the level of experience that those working in SFIU had in relation to deaths, sudden deaths. I'm interested in if you can help us understand why matters did not remain with SFIU but were moved to CAPD.
My recollection is it was because of the nature of this incident and because it involved Mr. Bayou's contact with the police officers on the morning of the 3rd of May that it was felt appropriate that the investigation should sit there. That doesn't prevent the team investigating it within CAPD having access to colleagues or expertise who work elsewhere in the organisation, such as SFIU, and both of those elements of work therefore come together at a more senior level involving Mr. McGowan and myself, and therefore part of our role would be to ensure that there was appropriate coordination and working together between these units. So allocating Mr. Brown at that early stage would not in any way have put any barriers in place in terms of access to people who worked in SFIU.
We've heard that this was the first PERC report that ultimately CAPD had received, the first case of this type that they dealt with. Was that taken into account when a decision was to appoint CAPD to the investigation into Mr. Pyle's death?
I don't remember that specific point. My recollection, as I say, is that it was felt appropriate for CAPD to lead on this and Mr. Brown to lead on it because of the issue of Mr. Bayou's contact with the police on the Sunday morning.
And was it your expectation that they would look to any guidance or assistance that SFIU could provide them?
Yes, plus the individuals in that team, I can't remember who they were now, but I would have expected them to have had, as many of us had, experience of investigating deaths under the previous model as well. So some of them may have had their own individual experience of investigating deaths.
We've heard that initially Alistair MacLeod and Erin Campbell were appointed to CAPD, and they prepared work and began to work on the investigation, largely to focus on creating the narrative of the Crown Recognition. Are you aware of their experience and background at that time?
Other than they were experienced Procurator Fiscal Deputies, I don't have any detailed knowledge of their background at the point. I'm not even sure what point they were appointed to the team.
They were appointed at a later stage after the final PERC report had been received by Crown Office.
I see. At that stage I wasn't involved, and I'm not even sure I was aware that they had been appointed.
All right. And were you aware that Fiona Carnan had been appointed to prepare the analysis of the Crown Recognition?
No, I wasn't.
Can I ask you to look at, first of all, perhaps can we look at the question 27 in SPPI 00441. This was the request for your witness statement, your response. It may be easier to begin with the question. And you were sent a document, a PERC briefing document, and referred to a number of matters. You were asked if you can look through the body of that. To what extent was the factual information accurate to your understanding at that point in the investigation? That was particularly directed towards the briefing note that was sent to the Lord Advocate. In particular, was it the case that Crown Office had instructed PERC in writing under Section 33A(b)(1) of the 2006 Act? And did you understand that PERC Flows had engaged with Mr. Bayou's family the night before, and PERC were confident that a relationship could be established? There's three different elements in that question. So the first is the briefing note, that was sent to the Lord Advocate. The second relates to section 33AB1, and the third relates to flows and the relationship. Can I ask you some questions about this? First of all, can I ask you about the instruction to Crown Office? It may be of assistance if we look at a document called a Memorandum of Understanding between PERC and Crown Office, which is PERC 04453, and it sets out the different sections of the Act that's referred to there. It might be easier to have that on the screen when we go through this. We can come back to that, but in the meantime, let's look at email COPFS 02685. And I'm interested in page 1. Now this is an email dated 5th of May 2015 at 8:35 hours, and it's from you to a number of people, the Private Secretary of the Lord Advocate, and then a number of people are CC'd into that. You see that?
Yes.
And if we can move, let's look at that. You enclosed a briefing received from PERC last night on the circumstances of the incident. And it says the key issue here is that Crown Office has instructed PERC to investigate the incident in terms of section 33AB1 of the 2006 Act, as, and this is in quotation marks, circumstances in which there is an indication a person serving with the police may have committed an offence. Now, we've heard evidence from other witnesses that section 33A B has 2 paragraphs, 1 and 2, and one is where they think a criminal offence has been committed, and the second relates to investigating the circumstances. Now, we've heard evidence from PERC investigators who were under the impression that they'd been instructed by the Crown to investigate the circumstances of Mr. Bayo's death. But in this email, you seem to be sending an email to the Private Secretary of the Lord Advocate saying, actually, it was an investigation into circumstances in which there was an indication that the police may have committed an offence, i.e. a criminal offence.
Yes.
Can you think back now to your recollection on the 5th of May and whether you did, as you have said there, think that this had potentially been a criminal offence that was being investigated?
Yes. So just, if I can perhaps clarify the purpose of this update, which was sent just after 8:30 in the morning. I think I've seen elsewhere, and it may be further down in this email chain, I think this was being sent in response to a request from the private office.
We can look at the bottom if that would help. If we look at the bottom of this. If we go to the bottom and then work our way up,
Yes,
sometimes these email
sorry.
threads are
Yes.
quite...
It's immediately just before my own email,
All
so
right.
if you continue going up, continue there. So this is a request to me, which if you could just go a little higher, it might show the time. Yes, that's as I remember it. So just early that morning.
So this is the 5th of May at 8:09 in the morning?
Yes, so the Lord Advocate's private office was requesting an update because, as you can see from the email there, the Lord Advocate was attending Cabinet, and so it was important. In those circumstances, I would not have had a chance to meet the Lord Advocate that morning, but it was important before he attended Cabinet that he was fully aware of everything that we had been able to establish up until that point in terms of the nature and scope of the incident and the investigation.
Right.
And so that was the purpose of my email, which I think was just
We keep going up.
typed
the
in
page.
response to that.
And this is the one that we look. This is your briefing.
Yes.
Sorry, I enclosed a briefing received from PERC last night. We've heard that there was a briefing dated the 3rd of May that had been prepared. We can look at that in a moment. And then this is where you say it's a 33AB1
Yes.
investigation.
Now, what I can't remember is when the formal written instruction was given to PERC. That wasn't something that I had been involved in. But what I was trying to convey here in that paragraph for the benefit of the Lord Advocate was, I think my recollection is that from the very beginning, given the report of the circumstances in which Mr. Bayou died, it was apparent to us that our death investigation would have to consider the question of whether or not there was any criminal offence on the part of the police officers who had restrained him. And I think that's what I was trying to convey here at that point on the Tuesday morning, was that we were alive to that issue and focused on that, and therefore, as is common in a number of, it's not unusual in death investigations that the Procurator Fiscal carries out for it not to be clear at the beginning whether or not the circumstances of the death involve the commission of a crime. And therefore, the role of the Procurator Fiscal is to consider at all times and be aware of that possibility, and if necessary to take the appropriate steps if it becomes apparent that a crime has been committed. And so, although the legislation is divided into two parts, that doesn't reflect the nature, I think, of many of the investigations that the Procurator Fiscal carries out, because it's not always possible to say at the beginning definitively that it's one or the other. There may be circumstances, as I understand there were in this case, where ultimately a full criminal investigation is carried out.
So was it your expectation that PERC were essentially carrying out what you've described as a full criminal investigation into the events?
It was my view at that stage that it was inevitable that PERC would have to, in investigating this matter, consider whether any of the officers had committed any criminal offence. That was part of our investigation, the Crown's investigation, and we would require PERC to investigate that matter on our behalf and provide us with whatever evidence they could find on that matter.
And was it your view that that was the appropriate section from the Act which PERC should be instructed under?
I think my reference to it then on the Tuesday morning was an indication that I did not. So, for example, if I had defined it by reference to subsection 2, that to me I would have viewed that as being too narrow an investigation. It was important to convey to the Lord Advocate and to others that we regarded this as being one of potential criminality.
And when you say others, are those persons in the Cabinet?
This is not necessarily information provided for the Lord Advocate for him to share at Cabinet, but it's important. It clearly was, by the Tuesday morning, a high-profile event, and it was important for him to be aware, not so that he could share any information with Cabinet, but if the issue was being discussed, it was important for him to be able either to intervene and make it clear what the appropriate role of Scottish ministers would be, and therefore in order to do that, he has to be fully briefed on what we knew at that stage. So it's a very common, in an investigation of this nature that's going to be large and complex, that's very high profile from the very beginning, that we seek to give the law officer as much information as we have, so that if they are, so for example in attending Cabinet, I can't remember who the members of Cabinet were at the time, but it's possible, for example, he may meet an MSP who has a constituency interest in the matter, or there are a number of things that may happen during the course of the Lord Advocate's day, and it's just simply at the start of the day giving him a full picture.
We've heard evidence that the first written letter of instruction was sent to PERC on that same day, the 5th of May. But at that stage, the instruction did not specify between B1 and B2. Was there a particular reason for that?
I'm not aware of any particular reason. I don't think I was involved in the preparing of the letter or sending it. So I'm afraid I can't help with that.
We've also heard evidence from PERC witnesses who said their understanding was that they were being asked to investigate the circumstances, effectively a B2 investigation, rather than one which was under B1. Can you explain why that impression would have been given to PERC witnesses?
I can't explain why they would have that impression. As I say, if I'd had the conversation at the time, I would have tried to explain it to PERC myself in the way that I've tried to explain it to the inquiry this morning, that yes, this is at this stage, this is an investigation into the death of Mr. Bayou, but it is important as that investigation proceeds that the investigators consider the potential for any evidence of any criminality.
So we've heard from you that you think Mr. McGowan was involved on the 3rd when PERC were instructed over the telephone to investigate the death of Mr. Bayou. We've heard it was you who was in position on the 4th of May. If it appears that there was some confusion on the part of PERC as to the basis upon which they were being instructed by the Crown in the period up until the 5th of May, can you explain how that miscommunication or misunderstanding could have arisen?
I'm afraid I can't. My recollection is that this email, as you can see, is sent to people within the Crown Office and Procurator Fiscal Service. I'm not aware, I don't recall receiving an email, for example, from anyone that it was circulated to saying that's wrong or that's incorrect. My view of that was that what I was sharing there was something that was apparent. There were a number of things that were apparent to us from the very beginning of this investigation, and I was formally recording there that one of those things would be the need for us to very carefully consider the question of criminality.
Thank you. In relation to there's mention of the briefing document there was in the question. Can we look please at PERC 03694? And you'll see this is dated the 3rd of May 2015, briefing note for Director of Investigations, death of Mr. Bayou, and then there's a document giving background information. Do you recognise that document?
Yes.
Is this the briefing note that was attached to your previous email to the Private Secretary of the Lord Advocate?
Yes, I believe it is.
And this was for sharing with the Lord Advocate?
Yes.
And can we look at page 2, paragraph 4? And you'll see there we've heard evidence about this. It says it was reported that as the officers drove into Hayfield Road, they saw the now deceased coming towards them as the vehicles came to a halt. They could clearly see he was in possession of a knife and was making his way towards them. Some of the officers, unknown how many at this stage, drew their police issue batons. At least one of the officers also drew their pava spray and issued a warning to the now deceased, who continued to come forward. So this appears to have been information that was reported in relation to the events at Hayfield Road, namely that Mr. Bayou could be clearly seen by the officers in possession of a knife, and after a warning was issued, he continued to come forward. In terms of that information, did you have an impression about the circumstances at Hayfield Road based on what was contained in the briefing note?
Other than the information that is described to me there, that was the extent of my understanding of what PERC were conveying in that note, which was dated on the 3rd, the Sunday. But I think it's important to say that my experience in complex death investigations and major incidents, and this investigation shares many features of a major incident, perhaps something that might involve the death of many people at the same time, is that the position is rarely clear at the beginning. Rarely clear. And so my own personal approach to these matters is that from the very beginning you have to work with the information you're provided, but you do not at any stage at that point in an investigation begin to narrow the investigation or reach any conclusions. You simply particularly at the beginning, are concerned to properly identify the scope of the investigation and make sure that nothing is missed. And so, to the extent I was able to form a view, it was simply no more than this was what was available to us at the time, and I didn't form any view beyond that, because in my experience it was far too early in the investigation to begin to form any particular view.
So in terms of your impression of this briefing note, I've asked other witnesses about whether they formed the impression that the police were acting in self-defence. Were you not forming any real impressions about the matter at this stage?
Well, it's difficult to recall the precise detail, but for example, it wasn't. I don't think it was necessarily clear to me. I could be wrong, and it could be clear elsewhere in this note. I don't think I've seen this note recently, but my understanding was that the PERC assessment was based not only on information from the police, but information perhaps from other members of the public who may have seen what happened. And therefore I assessed this as I was reading a summary of all of that. But the paragraph does say at points where they could clearly see, and there are reference to the police officers. So what I take from this is that the police officers were providing an account that was consistent with this, and that they described Mr. Bayou at that time as acting in this way. Whether or not that is actually what happened would have to be established during the investigation.
Did this information have any impact on your role and the approach you took at the outset?
No, I don't think it did.
Now, when I looked at question 27, I said there were 3 points, and one was the section 33A point, the other was the briefing note, and the final one related to the PERC flows. And you were asked if you understood that PERC flows had engaged with Mr. Bayou's family the night before, and PERC were confident that a relationship could be established. Was that your understanding as at this date, the 5th of May? Or had you been advised that there were some issues emerging in relation to PERC's engagement with the family?
So my email isn't on the screen, but I think in my email I'm describing, for the benefit of the Lord Advocate, that there had been some difficulties that Mr. Bayou's family had, I think without me really understanding the details of what had caused this, that they were understandably, as any family would be, concerned about how Mr. Bayou had died in circumstances where there were a number of police officers involved. And so I'm not sure that I was aware of anything more specific than that just that it was proving difficult in those early stages for the family liaison officers to establish a trusting relationship in the way that I would want it to be at the very early stages.
I don't want you to be at a disadvantage. Let's put the email back on the screen.
Yeah, sorry, that was, I'm not sure. I think
not
I said
so.
something about that in the email.
COPFS 02685, I think. There we are. And there's mention of flows in the 4th paragraph. We understand the transition of the investigation to PERC was completed yesterday, so that would have been the 4th of May, and that PERC flows have established contact with the deceased family. After an initial difficult meeting, indications last night were that the family were beginning to engage with the flows, and PERC is confident that a relationship can be established. So that would appear to refer to the previous evening, which would be the 4th of May, and that PERC were confident a relationship between the PERC flows and the family could be established. Is that what you're remembering?
Yes, now that I see that, that is slightly more specific than I could remember, but I'm clearly relaying to the Lord Advocate either information I've gained from any of the phone calls I'd made or any of the briefing documents that I read.
And does that, now that you see the email, does that accord with your recollection of the information you had on the 5th of May?
Yes, I see in particular in the next paragraph I go on to specify that Mr. Bayo's family had concern that what they had been told at the beginning to them just didn't seem right, and therefore that that alone, understandably, would make it very difficult for them to be, I suppose, willing to trust any official organisation at that stage that was trying to establish a relationship with them.
All right, thank you very much. I'd like to ask you some questions. We've talked about we can take that off the screen. We've talked about Article 2 and the 5 procedural obligations, and one of them is independence. And we've heard evidence that and you've mentioned that the post-mortem was conducted on the 4th of May. That was the Monday. And we've also heard evidence from Mr. Little, who was then the lead investigator for PERC, that he sought information about whether blunt force trauma caused the death of Mr. Bayo. And he sought that at the end of the post-mortem from Dr. Shearer, who was one of the pathologists who was carrying out the post-mortem. And the preliminary views at that stage, certainly by Dr. Shearer, were that blunt force trauma had not caused the death. We've heard evidence that that information from the post-mortem was later shared with the officers who'd attended at Hayfield Road. And I wondered if you had any thoughts or comments you'd like to share about PERC sharing information from the post-mortem with police officers who'd attended at Hayfield Road.
So without knowing the precise circumstances in which that happened, my starting point would be to assume that my guiding principle would be that the police were not carrying out this investigation. PERC was carrying out this investigation on the instruction of the Crown. This was an investigation which was led by the Crown and being carried out by PERC. I would therefore not expect, as a general principle, PERC to be sharing any information with any party without having discussed it with the Crown first. Now, whether it was then shared for any specific purpose in order to advance the investigation, I don't know, but I can't imagine beyond that there would be any basis for a discussion between PERC and the Crown as to whether it would be appropriate to share information from the post-mortem.
We've heard evidence from Mr. Little that he shared that authorised the sharing of that information in the hope that officers who'd attended Hayfield Road would then provide statements, which they'd not been willing to do up till that point. Is that something that you think Crown permission should have been sought before that was done?
I would have expected the sharing of any investigative material by the investigating agency, which has been instructed by the Crown to discuss that with the Crown before doing that.
And you've explained to us that Mr. McGowan wasn't present on the 4th, that Les Brown we've heard, hadn't been appointed until the 5th, but you were present. If you had been approached by PERC and asked for permission to share information from the post-mortem with police officers who'd attended Hayfield Road and who had not yet given statements, is that something that you would have been willing to give?
I think in the absence of there being a clear need in order to advance the investigation, I don't think I would have agreed to that. I would have wanted to protect the integrity of the investigation by ensuring that information was shared only at the right time and in the right way with correct people.
When you say a clear need, can you give us an example of what you mean by a clear need?
Well, it's very difficult to provide a specific example in the circumstances of this case, but if in a post-mortem the investigating agency thought it was appropriate to share information from the post-mortem in order to then find out something else, and I appreciate this is very general, it's difficult on the spot to be specific with an example, but if, for example, there was a need to test eyewitness evidence by reference to something at the post-mortem which was inconsistent with that eyewitness evidence, then that would appear to me to be a valid reason for the investigator to then, in appropriate circumstances, in the right way, share with that eyewitness that to test whether or not their evidence stood up to scrutiny.
And if it was shared to try to get the police officers to give statements, would you consider that to be a clear need?
Without knowing the full detail of what happened, on the face of it, no, that doesn't appear to me to be something that I would have agreed to just simply in order to encourage police officers to give a statement.
And if we've heard evidence that the information about the post-mortem was shared with the police officers who attended at Hayfield Road prior to the family being advised, do you have any thoughts or views on that?
I think that is especially problematic because I think we recognised from the very beginning that it was important in this case to have good, clear channels of communication with Mr. Bayou's family and to ensure that they were provided with information as quickly and as accurately as possible. In a case like this, where you have an understandable concern on the part of the family as to how Mr. Bayou had died and the potential involvement of others in that death, then it's very clear to me, I think, that a family would be very concerned to hear that information was being shared with others who may be, at the very least, critical witnesses as to how Mr. Bayou had died.
Thank you. I'd like to ask you some questions about rib fracture, and I'd like for this purpose to get you to look at a document which was a briefing note that was prepared in 2020, so sometime after, but it concerns and is in relation to this particular issue of the rib fracture. Could we look at COPFS 02126A, please? And it's quite a lengthy document. I'm interested in the section on rib fracture, but first of all, you'll see it was prepared by Alistair MacLeod, who was the Senior Procurator Fiscal Depute at CAPD on the 28th of February 2020, and it was sent to the then head of CAPD and copied to Fiona Carnan, who was the precognoser. And it talks about it's to detail and timeline the work carried out by CAPD between the 3rd of May 2015, the date of Mr. Bayou's death, and the 11th of November 2019. And if we can move down, sorry, I've not got a note of the actual page. There's a paragraph that is headed up in relation to rib fracture. If we can just go down, we'll see it. There we are. I'll just read this out. During the analysis of the statements, it was noted that 3 of the officers involved in the restraint had made reference to hearing the deceased fracturing a rib during the administration of CPR. Were you aware of the issue regarding the rib fracture in your involvement?
No, I wasn't. No.
The deceased's ribs appeared to be intact at the post-mortem on the 4th of May. However, a fracture to his left first rib was discovered following a further examination by the pathologist on the 29th of May 2015. That same day, Mr. Brown advised, that's Les Brown, head of CAPD at the time, advised Anwar and company and PERC about the deceased's rib fracture. In his statement dated 4th of June, PC Walker told PERC he heard the sound of a rib cracking when he was carrying out CPR. At this time, PC Walker handed over an undated, pre-prepared statement to PERC. Notably in this statement, PC Walker made no reference to hearing a rib crack during CPR. So just to recap there before we move on to the next page, post-mortem's on the 4th. They discover the rib fracture on the 29th of May. On the 4th of June, a few days later, the police officers give statements to PERC. And PC Walker was one of those officers, and he had prepared a statement himself. It was undated, and he handed that over to PERC on the 4th of June. And in that statement, which related to a period prior to the 4th of June, there was no reference to hearing a rib crack during CPR. If we can move on. Two other officers, PCs Payton and Tomlinson, also made reference in their PERC statements on the same date to the deceased rib fracturing during CPR. Within the PERC report, medical experts instructed by PERC put forward various scenarios as to how it could have occurred. The Crown carried out extensive further independent inquiries in relation to the deceased's rib fracture. Although the rib fracture did not lead to Mr. Bio's death, the Precognosers recognised that its very existence may have illustrated the force and mechanism of restraint used by the officers. And then there was reference to Professor Fremont, who was an osteoarticular pathologist and a specialist in bones. And then at the bottom of the page we see there it says, the Precognosers found it of interest that the information about the rib fracture, which was only being made known to PERC on the 29th of May, was somehow potentially being explained away by 3 of the officers when they provided statements on the 4th of June. After careful consideration of all the evidence, there was insufficient evidence to make any more of it, other than to say it was suspicious and potentially called into question the integrity of the PERC investigation at that point. Now, I'm interested in this matter, partly against that background of independence and the independence of PERC from the police service. And we've looked at this disclosure of the post-mortem, some information from the post-mortem on the 4th of May. And I'm interested in this briefing note prepared on behalf of Mr. MacLeod for the head of CAPD. Were you aware that there were these concerns about the integrity of the PERC investigation at this time?
No. No.
Had you been aware of these concerns about the integrity of the PERC investigation, are there any steps you particularly would have taken in this regard?
And just to clarify, you mean at the time in May of 2015?
Yes.
Yes. I think if I'd had concerns of that nature, I would have insisted on, at the very least, a meeting with the Commissioner to understand. I would want to understand firstly what had happened, why it had been done, and I would then work with colleagues to determine what the consequences of that were and what should be done, and that would focus on giving advice to the Lord Advocate.
And when you say what had happened and what had been done, was that both in relation to the post-mortem and in relation to these concerns about the rib fracture being mentioned?
I think I'm just offering a general comment on. I think your question was, what would I have done if I'd had any concerns? And I'm really just able to answer that in a very general sense, that if I'd had any concerns, if I'd seen anything which indicated to me that I had concerns about the independence of the investigation, then I would have wanted to address that directly with the PERC, not necessarily myself, but I would have wanted to have ensured that it was being addressed with the Commissioner themselves.
And you would have wanted to have ensured, presumably, it was independent of the police?
Absolutely. It was one of the features that I remember from the very beginning of this investigation, and you may come on to ask questions about my later involvement later in the summer, but I think there was another aspect of it then, was that PERC was a relatively new organisation, in the same way that Police Scotland was a relatively new organisation. And it seemed to me that there was a general lack of public understanding, and I would include in that understanding in the media or amongst people who would have an obvious interest, such as politicians. There was a general lack of understanding about the role of PERC and its independence. And I think part of my involvement later in the summer was to provide the Lord Advocate with information or briefing that would help publicly to try and make clear the distinction that PERC was operating independently of the police under the instruction of the Crown. This was not a police investigation, and I can't remember any specific details, but I have a general recollection that there was a sense in the early days that that Mr. Bayou's death was being investigated by Police Scotland, and it was important for us to be clear, not least with Mr. Bayou's family, that that was not the case.
Right. Can we move on to another topic? If we go back to your inquiry statement, paragraphs, this covers paragraphs from 61 to 75. There we are. And I'm interested, I suppose this relates to public scrutiny, media engagement, and I think this is where you talk about media engagement. At paragraph 61, you say Crown Office takes the lead in investigations and communicating information to the public in order to ensure that the release of information does not compromise the investigation or future legal proceedings. Releases of information by Police Scotland or PERC during an investigation are routinely cleared with Crown Office in advance. So is that your expectation, that really the Crown will be in charge and take the lead in communicating any information to the public?
Yes, in an investigation like this, the investigating agency is acting on behalf of and under the instruction of the Crown, and it's the Crown's ultimate responsibility to make sure that the release of information, as I say there, doesn't compromise the investigation.
Do the Crown also keep control of the extent to which PERC are permitted to release information?
That is my view. My view is that having been instructed by the Crown to carry out this investigation, PERC was in no different position from the police who would routinely carry out an investigation, and therefore I would have expected PERC to discuss and clear any public communication with us.
And you've mentioned the police, and does that situation differ regarding the police when it is members of the police service that are being investigated? Or do you still expect the Crown to have control and the authority to decide what information is released by the police?
I don't think it makes any difference who is being investigated, whether it's members, whether it's police officers or others. If there is an investigation underway, it is the Crown's investigation, and it's the Crown's responsibility to ensure that the release of information is coordinated and appropriate, and in the right circumstances also that the information, for example, that the family should not read about developments in the media. That's another consideration. So there are a number of factors that go into close coordination of the release of information. I should say, though, my experience is that it is often one of the most problematic areas in investigations, which are complex, moving at speed, and a number of different people and agencies are involved. I have experience in other investigations where information is released without having been cleared with the Crown, or experience of it working in the way that I would expect. I have experience of it working that way, where the information is discussed and the Crown gives its approval to the release of the information. In some cases, depending on the circumstances, that could extend up to and include the Lord Advocate approving the release.
And you've said that release of information can be problematic. What sort of problems can occur when information is released without getting the approval or the say-so of the Crown?
Well, I've already mentioned the problem that can cause for bereaved families. If it's not properly coordinated with information that's being given to the families, then you can end up in a situation where the families learn things through the media, and that is, in my experience, I have seen that happen, and it's very distressing for families. Beyond the interests of the bereaved relatives, our overwhelming priority is to ensure the integrity of the investigation and any subsequent legal proceedings. So we, in a general sense, we will always prioritise that over the release of information. If there is any concern, we will seek to ensure the integrity of the investigation.
You've talked about the investigating bodies. You've mentioned PERC, you've mentioned Police Scotland. Can I ask you, do the Crown have any authority to have some input or to take the lead on communicating information that is coming from other bodies such as SPF?
By SPF, you mean the Police
The
Federation?
Scottish Police Federation.
No, the Scottish Police Federation would not be part of any investigation, and therefore the Crown would take no responsibility for that matter. The SPF, to my mind, is essentially a trade union, and therefore it's a matter for them to decide what they do and say in relation to any matter involving their members.
So there's no involvement of Crown in approving press releases or anything of that sort?
I've never known us to be involved in discussing, never mind approving, anything that the Scottish Police Federation would issue. I'm not sure the Scottish Police Federation would regard it as appropriate either.
Perhaps not. Can I ask you to look at paragraph 62? We can see the beginning of it on the page. It was important to follow the media reporting of an investigation in order to ensure that there was no misreporting or misunderstanding of the investigation, and to ensure that the investigation was not prejudiced by media reporting. It's also necessary to ensure that Crown Office is able to answer questions posed by the media. This is a standard feature of all investigations, particularly in high-profile and sensitive investigations, which attract significant media interest. Investigative decisions are not influenced by media reporting. I've never been aware of this in my career of almost 30 years. I'm interested in your thoughts on what you say at the beginning of that paragraph. You follow the media reporting of an investigation in order to assure there was no misreporting or misunderstanding of the investigation. Can you tell us a little bit more about your concerns in relation to that, misreporting and misunderstanding?
Yes, I think what I have in mind there is that any misreporting or misunderstanding would almost immediately damage the confidence of the bereaved relatives in any investigation. And then more widely, as the investigation proceeds, I have experienced that misreporting or misunderstanding of an investigation can cause lasting damage to wider public confidence in an investigation, because inaccurate information simply becomes accepted as truth, just simply because it has been reported on a previous occasion. And therefore it's vital that, particularly in the early stages of an investigation where the facts are still being established and there may not be clarity, and in fact sometimes the understanding can change over a relatively short period of time, it's very important to understand what is being reported in relation to an investigation, and if necessary try to deal with the consequences of that.
Can you help us understand if there is misreporting, a misunderstanding could arise, or misinformation generally being shared in the media? What steps can the Crown take in relation to that?
There are a variety of steps depending on the context. If it was felt that that had arisen just simply because the media organisation had misunderstood something, then we would informally contact the organisation and try to have it corrected. If we felt there was something more substantive behind it, then we would really need to look at the precise circumstances and try to address that. That might mean engaging with people directly and more formally, asking them to refrain from continuing to misreport. If it came from an aspect of the investigation, then it would require us to take steps to make sure that that aspect of the investigation was no longer causing the misunderstanding. It is a feature now of our investigations that task that I'm trying to describe has become much more difficult, simply because of social media and the nature of modern reporting. Makes that a much more difficult thing to do. So at the very outer edges of what we are focusing on, it is unfortunately a feature of modern investigations that there will always be in some circumstances, very widespread inaccurate comment by people who know nothing about an investigation or are proceeding on a false basis. There's a very limited amount that the Crown can do about that type of reporting, but much closer to the heart of the investigation, if it's possible to do something to correct it, we would do that. And that would include trying to address any misunderstanding or concerns on the part of the bereaved relatives.
Thank you. Looking at paragraph 65, I think you say you've no knowledge of SPF's role. you have no experience of involvement in any other case and would not regard it as appropriate for Crown Office to comment on proposed SPF media releases because SPF was not an investigating agency acting under the instruction of the Crown. It would be for Police Scotland to deal with the actions of SPF.
Yes.
And so do you consider that to be something that Police Scotland would have some influence or authority in relation to, but not Crown?
Yes, from the perspective that Police Scotland operates as the employer and the SPF operates as the trade union, then I would have expected any actions by the trade union which were causing difficulties to be dealt with by the relative employer. I have to say, in making those comments in paragraph 65, I have no specific recollection of anything that the SPF did or said in relation to the investigation, and I could be wrong, but I don't think I was directed to any particular communication that they issued. So these are very general comments.
I'd like you to look at something for me. PS 04984. We've heard evidence about this. This is an email thread. And if we can go to the bottom, I think, and we can see the sort of first email that comes in. So this is from William Little, who was his role in PERC was Deputy Senior Investigator. And if we can look at the email he sent. So this is an email sent on the 14th of May 2015 to Keith Hardy, who we've heard was a police officer, as was Stuart Wilson. And the subject is Family Press Conference, Importance High. Morning, Keith, Stuart. The PERC was made aware of this late yesterday afternoon. John McSporran, he was the lead investigator by this time at PERC, spoke to Mr Anwar late last night, and it would appear that the thrust of this conference will be to criticise the police officer's decision not to provide statements regarding their involvement. The police officers had declined to provide statements at this point. And then the press release is copied and given here, Wednesday 13th of May 2015, from Amar Anwar and Company, relates to Mr Bio, and a press conference by the family on Thursday the 14th of May. So the press conference was due to take place on the same day that this email was sent. And if we can go through to the bottom, you'll see that press release talks about the investigation into Mr Bio's death. And can we look at the next email, please? Next one, further up the page. And this, if we keep going up, there's an email from Gary McEwen. We've heard evidence from Gary McEwen, sent on the same day at 8:08 to, in relation to the family press conference. And this is to someone called Lucy Adamson. Lucy, please see below. I think we need to be in a position to respond to this. I think the best avenue is most likely federation. We need to be quick with this. Will you link in with exec and feds around this, Gary? Alistair, please ensure all is cited on this development. So this has been forwarded by Gary McEwen, having received that from Mr Little. So it comes from PERC to Police Scotland, to Gary McEwen, and then is forwarded again. And if we can go up to the top of that page just for completeness, you'll see then that it's dealt with from DCC Local Policing to ACC Local Policing East. I'm interested in this situation where obviously the Crown have control over PERC, press releases, matters, communications about the investigation. But what appears to have happened here is that Mr Little, investigator with PERC, has forwarded something to Police Scotland, primarily Gary McEwen, and that has then by Gary McEwen been said the best avenue is most likely federation. But you've told us that the Crown have no control over Scottish Police Federation. I'm interested in this engagement here between PERC and the police being forwarded to the Federation in relation to comments which could be made publicly to respond to Mr. Anwar's press statement on behalf of the family. Do you have any concerns about this? Obviously, the Crown have control of PERC. They have control to some extent of the police, but this is being factored out to the Federation, of whom you have no control. Do you have any thoughts about this?
If I've read the document correctly, then what's being shared is a press release that was either public at the time it was being shared or about to become public. That's
Yes.
what that appears to be. And it's being shared from PERC to the police. That in itself, I would have expected. There obviously had to be a degree of coordination between the organisations. So PERC, in order to do its job, would need to have a relationship with, it would seem to me, with senior officers in the police in order to be able to progress the investigation. And what that email appears to be suggesting is that Police Scotland have, the nature of the relationship between Police Scotland and the Federation was such that Police Scotland could, I can't remember the precise words, I don't see them on the screen at the moment, but at least draw the Federation's attention to it, and perhaps in the expectation that the Federation would then say something publicly. That's simply my interpretation of what I've been shown.
I'm interested as well about the relationship with PERC, that they receive a press conference from that's due to go out for the family, information about that and what's to be said, but then share that with Police Scotland. Are you comfortable as in your role with information being shared by PERC with the police and then being forwarded to the Federation?
So it would depend on the timing. That looked to me as if it was being shared on the morning, and the press release was dated the 13th, so I don't know when that information, I don't know whether the information was public at the point this was shared or not. If it wasn't, then by the date on the press release it would become public. It wouldn't therefore appear to me to be investigative material that was being sent from PERC. It was media communication information that was being shared, something that was about to be, if it hadn't been made public already, was about to be made public about the views of the family.
So if the information does not relate to the investigation by PERC, do Crown have no concerns about that being shared with the police?
I think it would be wrong to say no concerns. I would be interested on the basis of this one example of knowing more. I think if I had known about this at the time, I would have wanted to know more about what was being shared and the extent of any information. So I think it would be wrong to say I have no concerns, but my concerns are moderated somewhat by the fact that this is not investigative material that's being shared, and therefore from the Crown's responsibility. It isn't material that is relevant to the Crown's own investigation.
We'll maybe come back to this. I'm conscious I've gone over the time, sorry.
We'll stop for lunch and sit at 2 o'clock.